I just need to quickly mute this before it does its usual thing. There we are. Mute, cool. Right. You're welcome, everyone. Just bear with me a sec. Got to do the usual gump here. That's done. Why is that not showing? There we go. Cool. Yeah, well, welcome everyone. Say hello in the chat if you're about. Nice to see who's here. It's just the three of us tonight. But we'll be back on Monday on his channel. You see the usual stuff. So if this is your first time, or even if this is not your first time, you can ask questions in the live chat. That's all good. If you ask the questions about yourself by saying, I'm in temporary accommodation, can you help me out? That you're basically having to put your personal data on the internet, which is not what we want. So basically just ask the questions of what if question. So what if someone was in temporary accommodation and they've been in for 8 weeks and they had kids, what would the law say? Something like that. You'll then get the same answer. You are Ginger. But you're basically not having to put your stuff out there, and it also helps you isolate the issue, so we can actually give probably a better answer anyway. It's not legal advice. We're just doing our best here to be helpful. We will try and quote the Homelessness Code of Guidance wherever we can, and a few other bits and pieces. And I think there's a couple of interesting LGSCO cases this week. If I just get one of them up, I haven't had time to read them yet because they come out Thursday lunchtime, and I've been busy. But here is one of them. So Wire Forest, and in this particular situation, Miss X basically went to the council because she was experiencing domestic abuse, and they delayed in giving her interim accommodation for 24 hours. So there's some good stuff in there about kind of it being a low threshold and stuff like that somewhere. Somewhere in there. Yeah, but basically she gets £500 for her avoidable distress and missed opportunity to access interim accommodation 24 days, sorry, 24, not 24 hours, 24 days sooner. So yeah, as I say, that's not quite as interesting as I thought it was then. But yeah, so there's some bits and pieces in there. It talks about the kind of the thresholds, the low threshold for making an application, and sort of here, so both reasons to believe and maybe are low thresholds. So that's that one. Shannon and Karis were just saying it's been a pretty miserable week when it comes to like reports coming out. So there's this figure of 80 kids dying in temporary accommodation. There's some other bits and pieces as well. So that's also miserable. Shannon, if you want me to share those links, I can and send them my way, and I'll put them into the chat. But as per how you are, Sebak, as per usual, we'll start the questions with the questions that have come in through the week that have been anonymized. So I'm trying to encourage people to put them in the comments before we get to this live stream. So you've got, first of all, you don't have a character limit, so you can actually kind of write what your question is without having to spread it out over 10 different posts. And it gives us a little bit of time to actually read them first, so we're like not, kind of taken aback, because we're not always going to know the answer, but we'll try our best here. So let me get the questions that have come. Oh, no, in fact, before we do that, that's what I was going to do. So basically, if you're subscribed to the channel, thank you very much. You'll get notifications. Thanks also for all the people kind of just commenting on videos in general. It's really nice and helpful. But you'll know the most recent video I did like 2 days ago, and it was basically based on a failing around a hospital, discharging people without making a duty to refer, basically discharging homeless people without doing a duty to refer. And essentially, you might also remember I was kind of talking about this back in October, but the FOI response, the Freedom of Information response, came back out of the blue 2 days ago. I actually completely forgotten about it. I didn't know what it was at first. But basically, what it said was that in the time period I asked for, so I asked the time period between January and October 2024, there were 208 patients who were identified as homeless. And the way the law says is that if they give their consent, which they probably will, the hospital needs to refer them to a local authority, a relevant local authority, and only 3 referrals were actually made. And I knew, the case I was involved at the time involved a very vulnerable individual who was discharged onto the streets and slept rough for a night before we could actually get them housed the next day. But there's undoubtedly going to be a lot more people affected by that. So just to kind of, I'm always going to try and encourage people and show people how straightforward it is to complain. That's the situation, and I'm literally just going to get ChatGPT to write me a complaint. So I've basically got some bullet points here that I made up before because I didn't want to take that much time over it. But if you can all see that, probably zoom in a little bit as well. So this is what I've asked it to do. So write a complaint to the chief exec of the hospital because their staff are not making duty to refers for homeless patients. This is based on information from an individual case where a vulnerable patient was discharged to the streets, and a subsequent FOI which showed that only 3 duty to refers were made, even though 208 patients were identified as homeless. Make the point that patients were discharged to the streets and that staff refused to make a duty to refer because the patient didn't have care and support needs, which, by the way, is not anything that's not a legal thing to do. And asked for the CEO to consider reviewing the duty to refer function and getting good training for staff so they can make effective referrals. Make the point that the failure to make duty to referrals almost certainly results in bed blocking and so waste taxpayers' money. So let's have a go with that. So this is it, just kind of working its magic. So sets us all that little template there. And I'm not going to read it all out to you right now because you can pause the screen if you really want to read it. But yeah, it's just basically done it for us. And although it sounds a little bit wanky in terms of the language, I'm going to just use this and send it off. So literally that's it, that's done. Right, so I will, straight after the live stream tonight, I'm just going to find out the CEO's contact details and send it off to that particular hospital. And that'll be it, that'll be done. So, and I'll let you know in a few weeks or a few months when I hear back from it, basically, just so you can kind of track it. And as I say, it gives you an idea just how little time it can actually take to get some good results, because if that hospital was to actually go and engage with this stuff really well, then it's going to obviously do a lot of good. Now, my battery's about to run out. So Shannon or Karis, could you quickly fill, because I don't even know where my, oh, so it's just here. All right, don't panic. I didn't know where my power cable was actually going to be. No, we're all good. So yeah, but yeah, that's, as I say, I'm always going to try and encourage people to kind of do that sort of thing when they see something's wrong. I get annoyed by the number of people who are outraged at everything, and then when you ask them what have you actually done about it, they say, "Oh, I haven't done anything about it." It's like, well, you know, stop talking about it then. So you know, let's get back to what I'm talking about. Here we go. I'm getting there. Sorry, guys. Cool. You'll notice I put this like line in bold here to try and just kind of encourage people just to stick to this rule. And the first question that came in through the week is a good question. It's a great question. It's going to be, well, it's not one we can answer here in any detail, but I will kind of say a couple of things about it. Let me just make that text a bit bigger as well. So, how do councils determine what is affordable rent? So this was actually this question was made on the video I did about paying for temporary accommodation, and you know, where councils have to make temporary accommodation affordable. But it also relates to general affordability, because if you're in accommodation which is not affordable, then you are legally homeless now. You don't have to wait to get into arrears and get evicted. You're already homeless. You can already get council help for it. The problem is that um, the law, there was a really good case in 2018 called Samuels v Birmingham, very, very clear cut. And essentially what that said was, when the DWP calculates how much money to give you, that is only meant to be for the essentials of, you know, the bare essentials of life, whatever they call it. And if you're having to pay out of that kind of living, you know, that kind of that general element of the UC towards your rent because there's a shortfall, then you would immediately essentially be homeless. However, the Homelessness Code of Guidance changed at exactly the same time in 2018 when the Homelessness Reduction Act came out, which basically changed the wording very slightly. And that allowed subsequent cases. One's called Bapty v Kingston, one is called Patel, I think. I can't remember which council it was, but it just muddied the water. At some point, we're going to do a proper video about affordability, but my understanding is at the moment is that it is just genuinely confusing, because I put a comment on Giles Peaker's post that he did about affordability and said, "Where's it all at?" And he said, "Well, I don't really know." So I genuinely think there's this ambiguity, and what that means is housing officers will basically use their own, you know, use what they think is right rather than actually any sort of guidance or any sort of like objective test. So that's when they'll start going through your bank accounts and saying that you're spending too much on food or too much on, you know, travel or something like that. So you have to be prepared for those arguments. You have to kind of, you know, essentially have to justify it. Now you shouldn't have to do that anyway, because what we still know is that it's still an objective test. It's not about what you're actually spending your money on. It's about whether you actually have enough money to cover those essentials. But there's just this kind of leeway that's been added into this kind of situation with this new case. Well, yeah, Baptiste's a couple of years old, and so it's just basically ambiguous. And so I think I have a feeling we're gonna have to wait until there is another case which it goes into more detail and actually sets some firmer, but kind of firmer sort of parameters and what councils can and can't do. So that is a massive cop out. But I genuinely think I don't think there is actually a correct answer to this right now. Because of these two cases that have happened and because of that change of wording in the code of guidance, which has snuck in the ability for councils to kind of make it harder for people to show that they're in unaffordable accommodation. But yeah, anyway, Shannon.
Yeah, it's not really anything to answer the question, I guess, but maybe some useful bits and pieces. So often when you're doing like an income and expenditure form, do declare if you're receiving PIP, but it does not count as income at all. So the local authority can't use it to sort of determine how much rent you could pay because PIP is calculated again for your disabilities or your needs. Um, and then the other thing, and I was only thinking about this today, really, but like, so we were talking before this started about the poverty report 2025 that was like published, I think, yesterday. And I do wonder, like, they've got in there the sort of different factors that push people into poverty and the different sort of definitions. And I do wonder if there's a link there. If you had a local authority saying, actually, yes, you can afford this private rented property or what have you, and you are going to a food bank, you could say, look, I'm literally like in poverty, or I'm literally and using those definitions, even though they're not necessarily homelessness sector related. Um, yeah, that's the only sort of useful things. And I guess, of course, like you can apply for DHPs and other discretionary payments from the local authority, but not an answer to the question. Sorry, just little things
Yeah.
to add.
No, that's thanks, Shannon. I actually have some bad news about the PIP thing because I was looking at it this week, and the case is this BAPT case, and I find the name of the case, the Patel one. I'm sure it's Patel. They essentially have allowed councils to start looking at that, even though they shouldn't be able to. They have started to look into, or they've started to consider using PIP for things other than what PIP's supposed to be for. So, as I say, it's just the when you actually look at the kind of Baptiste case, I'm like, I've read it so many times now. I just like, I don't know what it's talking about, but it seems to have just given councils a lot of scope for just being really unreasonable and really just kind of just
So
very negative approach. I know what you're
would
going to
that
say.
case law, no, but would that
Yeah,
case
yeah.
law override what the
Yeah.
government website says or not? I
So
know, like, regardless of what any case law or whatever legal documents say, what the local authorities at the end of the day will
yeah,
make whatever decisions is based on their own purse strings and their own issues as a local authority. But what
yeah.
trumps what?
So at the moment, it seems that the housing officers are trumping that kind of that position of the DWP.
A
So
lot of
so the
power.
yeah, yeah, I mean it's just um, I think it'd be nice if Will or Karis was there because they probably know a bit more about the way judges work. But my guess is it ended up in front of judges who weren't sympathetic to homeless people, and they just basically said some stuff which is just basically really kind of undermined the previous case law because it was the Samuels v Birmingham case, which is a really good one, was a Supreme Court case. So it was like this was supposed to be like a judgment which would last for ages, and it didn't. It just got undermined straight away by the Code of Guidance. It's the Homelessness Reduction Act again. Anyway, let's not whinge about that all night. But yeah. Um, yeah, yeah, cool. So yeah, but so I think it's not us being kind of completely useless. It's we actually just need to figure out what the law is, yeah, the position currently is. So it's a great question. Unfortunately, you're not going to get a good answer out of us tonight, other than to say that the DW, so the wording of the Bapti case does still say that the DWP amounts of money they give is still a starting point, but effectively council officers can then introduce lots of things which kind of depart from that starting point. So yeah, so question 2 from the week. My friend is threatened with homelessness but is in receipt of housing benefit. If she approaches another council and that borough has UC, will she have to apply for UC also? Will she lose the housing benefits? So I actually don't know the answer to this question either. It's not a good start, is it? But I think the answer is yes. I think basically you're essentially you have to start a new claim if you're going to be living somewhere, and that will basically result in it being a universal credit claim starting afresh. So having said that, my understanding is that you will get more money if you're on universal credit rather than housing benefit overall. So there's quite a significant amount more actually. So I don't know, Shannon, have you got anything to yeah say about this one?
I mean, it depends on how much the property is costing. Like, I'm very doubtful that property A in one area is going to cost the exact same as property B in a different area. So it's kind of not comparable like that. But you'd get the UC housing element amount. So it would still be the same thing. If the person is in supported accommodation, exempt accommodation, some sheltered accommodation, even if that area has UC, they will still get housing benefit instead. Because those accommodations don't go
Yeah,
through housing element. Um, but yeah, in most cases, people are better off in universal credit. Um, Depending on what other benefits this person's on, because it's rare that you're only ever on housing benefit. Um, Depending on what other benefits you're on, wait for your transitional protection letter, and your move to UC letter before making the transition. Lots of people, basically, once you move, there's a period where you get protected, so you definitely won't lose any money, and you'll definitely get the same amount or better than what you were on previously. People who move to UC before they get that letter aren't entitled to that protection. It's a massive gap because people think they're being helpful by applying earlier to UC, and then they obviously like lose out on the benefits. So if in doubt, contact your the current benefits people that you're currently on, whether that's ESA or what have you, the old star benefits, or contact Universal Credit because they have a move to UC helpline. And I've heard actually good feedback about that. So you can ask them loads of like what if hypothetical questions about what happens if you do move to UC. And you could particularly ask them about the housing benefit and housing element stuff. And as always, like if there's a local CAB, they tend to be typically hot on this sort of stuff as well.
yeah, cool. And another thing someone could do if that's the case. So technically, threatened with homelessness means you're likely to be homeless in 56 days. You can approach the other council at that stage. You can make multiple homeless applications. You could approach that other council in that prevention duty stage. They should assess your situation, and part of that assessment should take into account, or they should be able to tell you how much, or if they were competent, they would tell you how much money you might be able to get, because then you can kind of make a decision about actually moving there. So now I've just made that sound very easy. Oh, you just make a homeless application and just get the prevention duty and just get an assessment. But that's the way the law should work. The law should, I did a video the other day where essentially made the point that the prevention duty has absolutely nothing to do with the local connection. You can apply to any council in the country and you'll get the prevention duty. And the part of that prevention duty is about assessing your situation and kind of doing the maths and kind of working out exactly what your options would be. So that is another option. I'm not saying it's going to work necessarily, but I think that might be something that, yeah, legally it should help. Whether it will or not, I don't know. Um, so yeah. Next one here. Just checking. Yeah, okay. No, we've still got a few anonymized ones. So yeah, this one here. So someone has been given a Section 21 prevention duty has been accepted. PHP is in the works. Documents all sent. 2 months prior, put in an application to the housing register. Hasn't heard anything, and the housing officer keeps avoiding the subject, but says eviction process takes up to 18 months in some cases. And if then nothing has been found by the person themselves, they have private landlords who specialise in single occupants. Person has severe depression and anxiety, made clear they'll not do well being homeless. What are the chances of them being owed the main duty and end up in a ramshackled youth hotel? So so if you're owed the main duty, you shouldn't be ending up in a ramshackle kind of hostel, because but there's two ways to discharge the main duty. One is into social housing, and one is into a suitable offer in basically a 12-month assured short hold tenancy. And neither of them should be ramshackle because there are sort of minimum standards of that kind of accommodation. But I think the person asking the question here has kind of hit the nail on the head. It's all going to come down to whether the person's in priority need or not. So the kind of the depression and anxiety, which absolutely can make someone in priority need, but it's not guaranteed. That is probably going to be the kind of that's going to make or break that application. The whole thing. And I think it's really worth kind of if this person hasn't seen the video I did in this channel about bailiffs. So I think it's like you have to wait till the bailiffs come, I think is the name of the video, something like that. But if you just search for the term bailiff on this channel, you'll get that video. What you might need to do here is basically make sure that they accept the relief duty when they should accept it, which is the day after the Section 21 expires. That is when you are probably going to be homeless, unless the council think they have a good chance of getting the landlord to rescind the notice, the kind of the eviction proceedings. So, because yeah, I mean, the housing officer is not technically lying. In some councils with some courts, I'm sure evictions can take up to 18 months, but that does not mean to say that you're not, you shouldn't be getting assistance from the council long before. And in fact, so I'm going to actually just share a comment rather than a question that came in on the next one actually. This was just luck rather than me being clever about this, but so this was a comment which kind of talks about this a little bit. So, hi, I work in this sector. So they're talking here about kind of councils telling people to wait until the bailiffs come. I've seen all of this in practice. One thing the media never really picks up on is that the initial process of the Section 21 is designed to be an amicable process with a low cost to the landlord and ultimately the tenant. It's only when the initial notice isn't complied with that the landlord will start inuring third-party costs, court costs, solicitors, bailiffs, and the landlord will eventually usually ask for costs to be awarded at court. We've had cases where tenants would have had deposits returned, and had it not been for the court process, had it not been for the court process that the local authority made them go through. I do wonder whether this has been considered when scrapping the Section 21. That's kind of more talking about the kind of the change in legislation this year, but just kind of this makes the point quite nicely that this is always supposed to be like just kind of an amicable thing, but by councils telling people to wait until the bailiffs come, they can, you can be subject to not just the court costs, but if the landlord is kind of instructed a solicitor or even a barrister, I think can happen, then you're going to be looking at thousands of pounds. So it's really, going back to the question, it's just really important that you track when the Section 21 expires and just basically chase the council down to start the relief duty at that point. There is almost certainly going to be reason to believe that you might be in priority needs if you have severe depression and anxiety. Again, it's always going to matter. It's always going to depend on how that actually affects you, how that is likely to affect you if you were to become homeless. But that I think is going to be the key to that situation. I think otherwise you're going to get left in limbo for a long time, basically. And so, really, my guess here is that the housing officer is not aware of the actual of what the law says. We cover it most weeks actually because it's such a common question. If you go to the Homelessness Code of Guidance to 6.35 to 6.38, 6.39, something like that, you'll get the kind of what the criteria are for when you become homeless in the Section 21 process. And in almost all cases, really, it's going to be obvious when it's not, but in most cases, when that Section 21 expires, that is when you become homeless. And so that's when the relief duty starts. That's when the interim accommodation duty would start if you satisfy Section 108. So I think this person really needs to kind of, just pay close attention to that and ultimately really push the council. And I would say, although it's going to be delicate, I would say probably raising a complaint is not going to do any overall harm, because I would say if you just let it run for 18 months, then they're just as likely to say you're non-priority, at the end of it anyway. So you're probably better off just kind of taking the bull by the horns, having the argument with the council as soon as possible, so you're not just kind of sitting around. And they might offer you ramshackled youth kind of accommodation, say youth hotel, like like a YMCA or something. Um, you need to be very careful about what you're doing, but you probably don't have to accept that offer. So again, I think there's a really couple of videos on this channel which should be useful. There's one which is called When Can I Refuse Accommodation, and one is about will I get private rented or council housing. So check out those two videos because I cover this. It's really annoying. It's really complicated, but check out what I've said there. So yeah, but if you're owed the main duty, if you're in priority needs, and if you get through that far, then there's basically a higher quality of accommodation available for you with that process. So that's why it's so important. That's why we talk about priority needs so much, because it's going to be the difference between getting decent housing and getting nothing at all often. So final, I think there might be a question from the same person a bit further down actually, which kind of rephrases what we've already done. But let's just quickly do this one. So would a 22-year-old with ADHD autism living at home with his parents be able to claim rent through universal credit? They'd rather stay at home and support from his parents than live in a hostel, but his parents can't afford to keep him at home anymore. What are his options? So my understanding is you cannot claim housing benefit or housing element for like from close relatives if you're living with them. So whether that allows you, if if your parents own a different house to rent off them, I don't know. But if you're living with your parents, I'm almost certain you can't claim. And same thing if you're living with, like, yeah, I don't know how immediate the family needs to be, but certainly with parents, I'm sure you can't do that. So unless someone knows any more than that, or knows different, I think that I hope well, hopefully that answers the question, even though that's not a good answer. Um, so yeah, I'm just going to put this question. Just going to put this question in there. I think it's just a kind of a rephrasing of question 3. But let's have a look. So, what will happen to someone who is still under the prevention duty, waiting for the PHP, having doors slammed in their faces due to private landlords demanding guarantors? Council happy to help with upfront costs, but finding someone to take you on is without a guarantor is slim to none. Council says not to worry that as they have lists of agents who work with the DSS. I love that we still use that phrase. That's from like 1992 or something. That so the Department of Social Security is like, yeah, it's funny how that's kind of endured. But who specialise in single occupants. I wonder what those accommodations are like. Tiny bedsits or shared accommodation. So yeah, right, okay, so I can only answer for Bedford in that sense, but some of the landlords that worked with Bedford Borough Council were fine. They had nice properties, were decent people, and generally, although the council did work with the more roguish landlords, they didn't do it as part of the discharge of the main duty or one of the final accommodation duties because that quality of accommodation has to be better. They basically resort to those sorts of landlords when there were no other options. So, again, I think this might be the same person. So I think again, what you really want to pay close attention to is when this prevention duty is going to end. It will end when the Section 21 expires. That's when it should. That's when it should end. So yeah, and to be honest, like housing officers will always tell you to go and try and find private rented. They know full well that there's just not landlords around, but they just kind of do it because they know 1 in 100 people go and do actually find a landlord and not not come back to the council. So I think yeah, I mean yeah, but if you I guess technically well, I guess we've got to say keep looking for private landlords, keep trying. But if you keep getting knocked back, it's not you, it's just that there aren't any landlords out there. So yeah, do you guys have anything to add to that one? Welcome back, Harris. But yeah, anything to add to that one? If not, we'll get into the live chat. So let's see how we're doing. Um, okay, so what if you've been given full homeless duty but unable to bid due to being arrested nearly a year ago but not charged? So I don't see why you would not be able to bid. I can see why housing association might basically reject your kind of your if you were to win a bid. But yeah, I mean, yeah, I don't see what that'd be. Yeah, I wonder if it's just maybe the fact that the council saying like the housing association won't accept you, and I guess it also is probably going to depend here. Are there still inquiries pending? How serious is the crime? That sort of thing. But if it's a case of it's already been dropped and there's no further action or something like that, then that's the end of it. It should be the end of it. So unless there's a specific concern they have, then I can't see why, as in like you've murdered someone and well they think you murdered someone, then I guess they might be a little bit more reticent. Shannon?
Only other thing I can think of, because again, I agree with everything you've just said, is potentially if you were arrested for like a long period while the investigations were happening and then you weren't charged, like potentially they put a pause on your account and it's like an admin thing and you just need to sort of contact them and say, I can't bid. Sorry, I can't bid. Can you unpause my account or something? But like, you can ask. I know that sounds really like, I'm not trying to be facetious or anything, but like if you drop them an email and say, look, I don't seem to be able to bid on anything. Do you know why this is happening? They should be able to give you an answer. And if you still think, like, if you feel like they're fobbing you off in their answer, then maybe make a subject access request, and then you can sort of see behind the scenes what decisions they've made and why. Um, but yeah, that's sort of what I do in the first instance is to sort of email the housing options team or your housing options officer. Actually, often it's easier and quicker to go direct to the housing options team that's dealing with like the housing register and the bidding system than it is to go to your housing options officer. no, your homelessness officer, whatever it's called, wherever you are.
Yeah. Yeah, because I think every council will structure their teams differently. I mean, Bedford actually sometimes the best thing you do is just ring up the main receptionist because he's actually quite helpful. Just look on the file and say, oh yeah, it's just someone hasn't changed it or something. So yeah, I think in the first instance, just make sure it's not an admin error, and then I think other than that, you're gonna the making a subject access request will be a very interesting way of kind of getting hold of information to see what they're considering and seeing what information's been shared with housing associations, that sort of thing. So yeah, but I think yeah, unless there are still very serious concerns about the fact that the police might be saying behind the scenes, oh, we're gonna continue like investigating, we might well recharge later on. Then I don't really see, and I think even then, council that they have to kind of, if you haven't been convicted, you've not been under investigation, then they should just kind of proceed as they should do anyway. And then if you were to go to, sounds terrible, if you were then to go to prison, then well, then okay, you might lose your accommodation later on, but they should still be processing things at the time being because you're not being convicted of anything yet. Um, Next question is this one here. So, just this font size is annoying me now. What's that? That's 12. Hold on. Can't deal with it if it looks weird. There we go. So yeah, 27-year-old autistic person suffering from anxiety and depression. He's getting support letters from his autism team as he has sensory issues and from his community mental health team as he's suicidal. How do these supporting letters need to be worded to housing? So it's going to depend, I guess, on what the issue is at hand. So if it's a case of, is this person in priority needs, then they need to focus very sharply on what is going to happen to that person if they were to become homeless. Are they going to be at risk of exploitation? I would imagine their anxiety is going to get worse. How much worse is it likely to get? What is that going to lead to? So that would be, as I say, if it's a case of a priority need situation. If it's a case of suitable accommodation, then you would again you need to get supporting evidence to kind of explain what is likely to happen to you if you were in a block of flats which had lots of antisocial behaviour or was very noisy. If it was a case, I guess technically it could be seen in intentional homelessness, so where you've been found intentionally homeless, but actually something about the autism was just kind of meant that the person struggled to maintain the tenancy or something like that, then you get evidence that pertains to that. So I think that's the kind of thing is you need to kind of work out what is the argument you're going to have with the council and then get your supporting professionals to essentially kind of give as much detail as they can based on what they know about you about that situation. So yeah, do you guys want to add anything onto that at all?
I don't know if you said it or not, but just highlighting if a person has a disability or not. Um, so therefore, unlike any reasonable adjustments and laying it out that way, so you're protected under the Public Sector Equality Duty and the Equality Act and stuff. It basically just means like, yeah, local authorities have to take extra considerations whenever they're making any decision. Um, so it's quite a handy tool to sort of have if you can, or if it's relevant, sorry.
Yeah, cool. Um, oh, I need to actually copy and paste the right bits. So there's quite a long question coming up, but it looks like it's pretty. Oh, what's going on here? Sorry, guys. YouTube's not letting me copy and paste text for some reason. Here we go. So there's multi-part. As I say, just to reiterate, guys, if you've got complicated situations to ask about, that's not a problem. But you might be better off just putting it onto any video on the channel because I get notification. Probably want to do it before 6 p.m. on a Thursday so I can kind of have time to actually go through it. But it just makes it easier than kind of doing it like this. But yeah, we'll follow it. So okay, so my friend started a homes application, has been assigned a notoriously difficult housing officer. He's diagnosed autism, severe anxiety, and depression. Is currently with the crisis team after a recent breakdown where there was evidence of suicidal intent. He's due to leave the family home next week. Abusive father returning from abroad and applied for help a week ago. The housing officer downplayed the abuse and said maybe it was just tough love. Since applying, he hasn't heard back at all. Radio silence despite only a week ago. He called the council who said the officer noted evidence needed but hasn't even contacted him to request what evidence request any. What evidence would you give a vulnerable person dealing with a difficult housing officer? His support teams are willing to write letters and provide evidence. Okay, so really good question. Um, I guess I'd start by saying some housing officers are like the worst people on earth, in my opinion. They're just the most disgusting individuals, incredible bullies, incredible abuse of power. And I think realistically, someone who is going through homelessness, I'm not sure that you can really win. So I think I guess my first thoughts would be about kind of trying to find an advocacy service, or trying to find a professional who can help you through this process, and effectively probably avoiding talking to them on the phone or in person as much as you can. Keep it all in writing. Um, just to reiterate, the kind of the threshold on evidence for domestic abuse within the homeless application process is if the person reports that they're being abused, then the default position is to believe them. So yeah, I mean, I guess I would say probably if you can reach out to a domestic abuse charity, they are probably gonna, well, they will understand domestic abuse really well. They may be able to provide some supporting evidence to kind of say, actually, this is about the dynamic, and this is how it's affecting someone, and that it is classed as domestic abuse, because domestic abuse is essentially um, any type of abuse from an associated person, or a connected person. I can't remember which the phrase is now, but that would basically be any family member who's related by blood or marriage, plus former exclusive relationships, that sort of thing. So yeah, I mean, it may well be domestic abuse. I would say you might want to, as I say, approach other services and see if there are domestic abuse specialists. I mean, I don't know, probably isn't one in the autism and kind of the mental health team, but there are some mental health teams with a domestic abuse lead. So it'd be a case of kind of requesting to speak to them and speak to your workers as much as you can. And essentially, like, in if you had kind of a lot of contact with the crisis team and other teams, they should have been recording what you're saying. And if you said to them over a period of time that, this is what's happening, this is the risk the father has, or whatever, then that is all, those notes can all be used as evidence. You shouldn't really need it, but when you've got a really bad housing officer, that's kind of what you have to do. So, but yeah, I mean, yeah, the professionals regularly essentially collude, and also, they kind of mirror abuse, and make kind of abuse worse, make domestic abuse worse. So yeah, Shannon Lakaris, you got any ideas, any additional things to say on that one? It's a very difficult situation to say. I would say the odds are stacked against you in that situation. I think you got to try and find some way of readjusting those odds.
I mean, I would potentially, depending on, I guess, how much you want to be in that area or how much you need to be in that area, I'd potentially even think about approaching a nearby local authority, to have a different housing officer and to sort of potentially have a nicer time of the process. Um, I did wonder as well, like, and I know, I mean, the whole thing is a bit BS, right? Like, you don't need to ask for evidence. It's not on a housing options officer to decide what's abuse and what's not. Um, but the fact that housing officers also missed the fact, and correct me if I'm wrong, Mike, because I'm rusty on the Domestic Abuse Act. But if you're a witness in a family home to domestic abuse, you also count as living in a domestic abusive household. So if this person is leaving the family home, even if the father is only abusive to the son and not to say other family members, wouldn't that whole family unit still be at risk of domestic abuse?
I need to check the
Or
wording.
yeah,
I think it applies. It's certainly that's primarily aimed at children, so under 18s who witness domestic
right,
abuse
okay.
between parents. It's quite strange how the Domestic Abuse Act divides up age, and stuff. But yeah, I think that's more talking about that. But
Do you, do you think it would also help if workers perhaps made like a safeguarding alert, and sort of, just to sort of reiterate, and again, I really want to like highlight this shouldn't be needed if you're fleeing domestic abuse, but to reiterate and highlight the sort of abuse, and then it's coming from a professional as well. Um, and that should sort of add some weight to what the client's saying.
yeah, I mean, so if you look at, because one of the things you could do is basically, and yeah, you could search for the council's adult safeguarding policy and look at the wording of that. every policy is different, but they tend to be quite similar in the sense that they'll probably say something like, if someone reports that they're being abused, then the worker must immediately refer that case to the safeguarding team. Now, this person does have care and support needs in the form of autism and depression and anxiety. So you'd be in the ballpark of kind of engaging with social services anyway at that point in terms of if a safeguarding alert was made. But that assessment process in the safeguarding alert might also kind of provide additional information that would you then kind of take back to the housing officer. Just to add to this last bit, so I missed it before. So how should the evidence be worded? His support teams are asking if he'd like amendments to best support his application. Any advice? So again, it's not, there's no kind of magic wording. Workers need to give the best evidence, the best detailed evidence they can about whatever the issue would be. So in this case, it might be that worker says, you know what, Joe Bloggs has been in contact with us for many months, has been very distressed, kind of suicidal ideation, and on numerous occasions has told us that they are in fear from their family member or something like that. If that evidence has kind of been recorded as it should have been along the way, then effectively it might just be a case of pulling out those relevant records from the file and then kind of giving a summary saying, based on these summaries or based on the reports by this patient over the course of several months, we believe that there is a significant risk of further domestic abuse, that sort of thing. I mean, I just guess in this situation, just to kind of take it back to basics, um, the if you can show that you're homeless, as in, is it probable the abuse will continue in your home, which essentially is what this person's saying, then you're homeless and you're immediately in priority need as well. And so essentially the council is going to have a duty to provide interim accommodation if you're also potentially eligible for assistance, which means having recourse to public funds pretty much. So, but there's no magic wording, and I think any professional should be suspicious if like they're being kind of fed words to say. So you shouldn't. There's no like sort of template letter, but you want to get them to give their own professional opinion about, in this case, the probability of there being further domestic abuse, whether there is domestic abuse already. That sort of thing is going to be the thing which is going to win the argument legally. But when you have absolutely disgusting housing officers out there, even winning the argument legally won't necessarily actually win the argument. So you, as I say, you might be that you approach a solicitor, see if you can get solicitors on board, that sort of thing. So yeah, it's probably going to. I probably don't ask for more information over the live stream because obviously there's implications there. So I probably want to leave this situation for the time being, but just say that you need to get a decent, knowledgeable advocate on your side, however you can. So, I mean, if you Google W Flack Law, Will Flack Law, so wflack.com, I think it is, there's a section in there which is like all the different solicitors firms that take legal aid for housing cases. And it might be a case of ringing around those. I really wish that professionals out there were competent with this sort of stuff because it's so important, but a lot of them aren't. But I think, yeah, I think you're right. I think that it's a difficult case, it's a difficult situation to win. So yeah, sorry about that. Sorry, that's not a very positive answer. Next question is a little bit more straightforward, fortunately. So can the Housing LA do a Section 189 referral prior to accepting any duties? Absolutely not. Basically, they have to accept an application. They have to provide interim accommodation if there is reason to believe that you might be homeless, might be eligible, might be in priority needs. The prevention duty would start if you are threatened with homelessness, and that is completely irrelevant. That's not relevant to local connection. And the assessment and PHP should also be done before they look at Section 198 referral. I did see an LGO case this week, an interesting one for a number of reasons, where a survivor of domestic abuse approached a council. They tried to refer them back to their home area, even though there was some risk there. And they kind of went through all the steps, and basically the other area just didn't respond. And after about several months of kind of waiting, the first council just gave up and just accepted the duty anyway. But yeah, so Section 198, I mean, it'd be really stupid for a housing officer to do that, because a lot of housing officers would simply say, we've got no duty, off you go back to your home area. But if a housing officer is going to say, okay, no, we're going to make a Section 198 referral, but they hadn't accepted the homeless application, they hadn't done an assessment, they hadn't done a PHP, the council receiving that Section 198 referral is going to be like laughing at it basically and completely blanket. So I think that just sounds, if that is as simple as that situation, then the housing officer clearly doesn't know what they're doing. And you might just want to draw their attention to the Homelessness Code of Guidance and kind of just make the point that, yeah, as I say, these initial duties start before any kind of like, that kind of Section 198 referral takes place. Anyone want to add anything to that one at all, guys? So I'm going to call time on further questions. So obviously going to answer the questions that are in there. But it just means that we're not going to get overrun. So further questions to be asked next week, or if you're sensible, just to stick them on a comment on the channel, because then it will kind of jump the queue a little bit. So let me just kind of, I know there's a bit of chat going on here rather than questions. Let me see what I can find. So interesting question here. Question 10. If someone is bailed to stay away from their house due to assaulting a neighbour, can they get temporary accommodation as a homeless person? A bail address was provided, but they can't actually stay. So that's a whole different legal issue in terms of the bail. You've been bailed to an address where you can't stay. That's a problem with the police that they need to sort out. So I can't really comment on that. So, but yeah, in terms of in situations where you have a court order or something, or kind of non-molestation order, bail conditions, a closure order, all of those kind of situations, you would legally be homeless because although you've got accommodation, it's not accommodation which is available to occupy, which basically means you're homeless. So if you were also potentially in priority need and you were potentially also eligible, then the council would have an interim duty to accommodate you. Bearing in mind, they're probably not, they're probably going to be rather prejudiced against the person in this situation. So they're probably not going to be very helpful. But yeah, the duty, those initial duties, a little bit like local connection, do not kind of take intentional homelessness into account. I mean, this person, I mean, obviously there might be more to this. Maybe they were acting in self-defense or something. But generally speaking, if you assault a neighbour, then you might well get evicted for it potentially, and that could then lead to an intentional decision. But those initial duties don't take that into account at all. So a council would potentially, as I say, if that Section 108 threshold is, let me share the code of guidance just to kind of say what I'm talking about here. Try and slow down the amount of jargon I keep going on about.
Well,
Oops,
and
go on, Karis.
yeah, sorry. I was just going to reiterate I think you did say it. You could be found intentionally homeless because this is because of your actions. Although it's not an automatic and you could have mitigating services to challenge it. But if you provided a bail address, you've got to provide evidence that it's unsuitable and why it's unsuitable. So all that sort
Yeah,
of stuff has got to give.
yeah, I mean, I'm pretty sure. Like, yeah, I think they're obviously. I don't know enough about criminal justice law to know what's the deal. But if you've been bailed to address and you're not staying there, then presumably you're at risk of being rearrested anyway.
Mm.
So you would need to go to the court or go to the police or whoever it is that does that stuff and basically get them to like change the address or probation potentially. I don't even know who would do it, but um so this is I keep going on about I've said it a few times, but this is so 15.4 the code of guidance. It's Section 108 of the Housing Act 1996 says that so Section 181 requires housing authorities to secure that accommodation is available for an applicant and the household if they have reason to believe the applicant may be homeless, be eligible, and have a priority need. And the way you read that is may be homeless, may be eligible, may have a priority need. So notice that that does not talk about intentional homelessness, doesn't talk about local connection at all. That's the threshold to get interim accommodation or emergency accommodation, as it's better known. So as I say, I just want to kind of throw that in just to sort of try and slow down what I'm saying and make a bit more sense. Hey, you what, Cheeseface? Nice to have you here. Yeah, good question. So I probably need to do a proper video about this at some point. So personalized housing plans. What information is important to put down? As I understand, this document is important and will be referred to in future. So you're absolutely right. It is actually really important because if a council doesn't do it right, as in they don't take into account the right information, then other things they then do down the line. So, for example, if they don't pick up on the fact someone has a disability, and then they try and put you in a unsuitable accommodation, and it becomes very easy to show why the council has not followed the law. So I will do a proper video about this. The things you want to definitely put in there are details about your disabilities and what things the council need to do in response to that. You also definitely want to put stuff in there about any risks that would be posed to you in particular districts or particular areas. You definitely want to put stuff in there about employment. You definitely want to put stuff in there about kids' schools. You definitely want to put stuff in there about support network. Um, there's other stuff you want to put there in there as well, but I probably can't think off the top of my head. I've had a very long day, but we need to do a proper video about this one at some point. So yeah, basically it. Although housing officers will kind of do it as like some sort of tick box exercise, it's a template. They don't really care what's in it. Actually, that document kind of serves as a framework to then define what the council then does in terms of offering accommodation if they have a duty to offer it. So it's really important for sure to kind of make sure you've raised everything that needs raising. You've corrected things that they've got wrong. All that sort of stuff is definitely worth the effort. Karis, I don't know if you got more to say about this one, because I know this is something which you probably see a little bit in the old casework.
Yeah, so your housing plan basically is what they terms and what your needs are. So if you probably have a problem with the stairs and have problems with mobility, so if you can't do the stairs or you'd need a downstairs flat or a bungalow, that sort of thing, downstairs bathroom, it's about your financial situation, your health, everything is in there. And that can be, it's like a living document that evolves with your situation as well, it's supposed to be. But and also goes on what your situation is now. If you're, say, you've been served a Section 1, but you're at risk of homeless, but you're not homeless, or if you're street homeless now. So if you need emergency accommodation, if you're street homeless, your medical needs, your disabilities, your care needs. So this is where you talk about your mental health, or if you're at risk of domestic abuse, you don't want to be housed near a perpetrator, so you can't go in specific areas, so preferred location, things like that. So it's about their legal duty and what the council owes to you. Will be in there. It's like a template document and it's got a table. But like you said, you'll probably do a video on it, and it'll be good to have a live one that the council actually use, maybe.
Yeah. I mean, it's quite easy to get templates that they use. So yeah, as I said, that's I think I need to kind of do a bit of research on that and kind of put something together that's a bit more kind of comprehensive than doing it on the live stream. Are you right, Martin?
If they get it wrong, you challenge it, you put it in writing, say this bit's wrong because, and write that email down.
Yeah. So there's a case, a really good case, very helpful case a few years ago called YRV Lambeth, where they were placed in Gravesend, and essentially it all came down to the quality of the assessment that was contained in the PHP, or in conjunction with the PHP. And because the council they didn't assess, they didn't actually ask the question, what does these different family members need? They lost every other kind of argument that happened after it, because they were not able to show that they knew that the accommodation they offered was suitable. So yeah, it's an important document. Just to kind of reiterate what's been said there. I think there's some questions coming in about our kind of the point I made about PIP. Now, as I say, like I can't because the question is, does that also apply to limit capability for work group? Shannon's shaking her head there already. So, but yeah, I think the answer, if it's not the case with PIP, then it won't be for limit capability group either. But Shannon, you got anything to?
So the limited capability for work and work related activity is income related, because so if you don't have housing costs, you can earn up to £673 a month without it affecting your benefits. If you do have housing costs, it's £404. So because it's income related, it does count as income. So you do have to, with all these things, like you have to declare them. Like you don't be lying to the local authority in any. That's not the advice. Yeah, it's a different ball game for LCWRA
Yeah.
than it should be for PIP. But like you said,
Yeah, and I need to confirm that for sure, but I'm pretty sure PIP, they're taking it into account. So just someone's just saying there, because I think we were talking about, can you get housing element or housing benefit for a family member's accommodation? So there's a case there, some saying that where the parents own the home but they weren't living with their family member who was staying there, and there was a tenancy, and that was okay. Which I think, as I say, I think the kind of the definite prohibition is where you would be living with your parents. So if you're living with your parents, you could not get universal credit to cover any sort of rent payment or anything like that. So I guess it's more of a comment here than a question, but it leads to a question. So no, not that one. Come on, YouTube, please. Is this going to do it now? Yeah, priority needs a bit difficult to prove in mental health. If the person is very clearly communicating, actively looking for accommodation, they might not even believe that the person has depression. So yeah, this is the kind of crazy sort of catch-22 that housing officers say. They kind of say, well, you're well enough to make a homeless application, you're well enough to be here today to meet me, therefore you can't be in priority needs. So that's I'd say it's kind of very common sort of argument you hear from housing officers. However, it's only scratching the surface in terms of what priority needs really about. A really good case, if you want to see this in action, is Thomas v. Lambeth. So that was a case where there's a lady who had moderate depression, but was shown to be in priority need. And it was things like kind of social anxiety and kind of I can't remember if it's hypervigilance was mentioned, but there's a whole kind of number of things that the doctor was able to evidence to say, actually, that this first of all, she's got this kind of significant but not extreme depression. And being homeless is going to make that depression get worse, which is a harmful thing in itself. So that then she was found to be in priority need. So it can be difficult in the sense that you're often going to be relying on medical evidence. And if you've got paranoia and you haven't been to see your doctor because you've got paranoia, then obviously it becomes quite difficult to evidence. But the actual threshold is not very high. Lots of housing officers, misapply the threshold basically. Shannon.
Yeah, I mean, in the Thomas v. Lambeth case, wasn't it even like how long it took her to like open letters and stuff? I feel like that was all sort of discussed. But I think it's also worth just mentioning, I mean, Ada's person is exactly right. And for the record, if you go in and look depressed, you won't be any better off either. Like, do you know what I mean? You won't win either way. But just a point on medication. It doesn't matter if you're on medication for it or not, like in terms of making that argument and sort of showing priority need. Lots of people will be too depressed to go to the GP and to sort of seek that help, or to, lots of people don't agree with medication for lots of different reasons. But just, I think that's quite a common thing we hear from housing officers is like, oh, well, you can't be that ill. And that accounts all sort of illnesses, not just sort of mental health illnesses. You can't be that ill because you're not on medication, or whatever it is, you're not engaging with treatment, or like there's lots of different reasons why people choose health related decisions. So that's not the test for priority need. I've really mashed up my words there, but does that make sense?
Yeah, it's good. I mean, you raise another kind of catch-22 where you say, like, they say, well, you are engaging with the treatment, so you're fine, or they'll say you're not engaging with treatment, so you're fine. So you kind of have this situation where, like, as I say, but the test is what is going to happen to your health issues, your mental health, your physical health, if you were to become homeless. That's the end of the test. If there, essentially, if you have any pre-existing conditions which are likely to, get worse and lead to harm, that's essentially the test. There's not a lot more to it than that. There's some detail, but and the kind of this use of the word significant is interesting because significant means a range of things. It can mean, anything that's more than trivial, or it can be used to mean something that's kind of quite weighty. But the case that followed the Hotak case, which is like the Supreme Court judgment, which kind of set this stuff out, which was Paniotu v. Walden Forest, they switched the word significant for the word noticeable. And so essentially, there needs to be noticeable, the kind of the additional risk to you needs to be noticeable compared to a healthy and robust person. That's the kind of legal test. So it's not a high threshold. But
Noticeable to who?
As into the housing officer. So yeah, it needs to make a noticeable difference. If I said, I've got a bit of tennis elbow, doc, can you they'd be like, well, no, not really, because it's just, it's not very significant. But where you've got something like depression, which is obviously going to impact people in a range of different ways, if it's going to do something to put that person at additional risk of harm noticeably, then that's kind of it. So.
All right, can I just add
Yeah,
on that bit? So everyone needs to remember that the housing officers and the council aren't doctors. So when they say things like, you don't look depressed, it's like that's an issue for a complaint. The fact they even said to you, oh, it's just tough love. These are issues for complaints because it's not their place to say. So when you talk about depression, talk about how it impacts your daily life and how it affects you and what activities how it limits you. and things like that. So it would make you more vulnerable on the streets than an average person. But they're not doctors, and if you've got the doctor's evidence, and that should be all they need, they have to go away and make their inquiries and just say, we don't look that depressed. It's not their decision, and that is a complaint and completely challengeable on those words. It's for words.
Yeah. So what councils will often then do is send it to their so-called independent medical advisor. But again, just as Carissa said, the independent medical advisor never speaks to the patient. So any records you have from your own treating team should be given a lot more weight than now medical or any other medical advisor. But it's a kind of very common issue. So yeah. Next question is a good one, but I don't know if I know the answer to it. So if a housing association or council tenant is making a number of vexatious, untrue reports towards another tenant nearby, the landlord is obliged to say who's doing it, aren't they? I can give you a bit of a related answer. So I worked with a lady who was quite difficult to be in the same block as, let's put it that way. And a number of her neighbours raised complaints, and I think they were told that they were going to be kept confidential. But when it goes to court, they will all be listed. Their names will all be listed. The neighbours were, and what their neighbours said about this other tenant were all kind of included. And luckily, the individual, although was quite difficult, she wasn't nasty, so she didn't go and kind of cause any trouble with it. But yeah, I don't. I think that if they're going to if they're going to take any stuff forward, then generally speaking, it will be discoverable. I guess, yeah, I don't. Again, I'm outside my sort of area of knowledge here by quite some way, but I guess unless there is kind of a clear retaliatory kind of risk, danger kind of identified, I don't know. I don't know if either of you guys know this one. But yeah, I know certainly they can. The names of complainants can be disclosed. I'll leave it at that. That's all I know for sure. Whether there will be situations where they don't necessarily get disclosed is I'm not yeah, so I'm not quite sure about that.
Wouldn't data protection stop them from being disclosed at an earlier stage? Like if it was just like someone going, "Oh, who's made that complaint against me?" Surely data protection protects the identity of the other person, and so they wouldn't be able to disclose that information
Maybe
because it's not
maybe
in public
early,
interest or anything.
maybe earlier in that complaint, but
Yeah,
yeah,
much like before it gets to
when it
court.
yeah, when it gets to court, as I say, like yeah, that they were all kind of rather miffed that they'd been named and they hadn't been told that they would be named. So yeah, I don't know. I think we have to kind of say Jerry's out slightly on that one, but certainly yeah, it might be. We know it might be. That's all we kind of know. Um, so what are all of the possible legal repercussions? Um, no, come on, hold on. What are all the possible legal repercussions of not disclosing a change in circumstance to the council, or you see that someone is no longer homeless if they have moved into a property guardianship? So I'm going to partly answer this by just going to the Homelessness Code of Guidance to kind of, because obviously some changes of circumstances aren't significant and other ones really are. So if we go to, I think 18.14 or something like that. Nope, not that one. Yeah, 18.10. So under section 214, it's an offence for a person knowingly or recklessly to make a false statement or knowingly to withhold information. So that'd be a case of change of circumstance. So you might have told them the right stuff initially, but then if you knowingly withheld something that was significant with the intent to induce the housing authority to believe that they or another person are entitled to accommodation or assistance under Part 7. Part 7 is just the homeless application process, by the way. If before the applicant receives notification of a decision, there is any change of facts material to the case, they must inform the housing authority of this as soon as possible. Housing authorities must ensure that all applicants are made aware of these obligations and that they are explained in ordinary language. Housing authorities are advised to ensure that obligations are conveyed sensitively to avoid intimidating applicants, because it is a very kind of intimidating thing to say. Now, I don't think you can go to prison for it. Let's have a look. So Section 214 of the Housing Act. 1996. Because I think it says here about the penalty.
Are you wanting to share that screen, or are you still wanting to
No,
be on the code of
I'm gonna
guidance?
find it. No, it's all right. I'm just
Okay,
gonna
cool.
stick it in. Yes, thanks, Shannon. So this is what section 214. It says quite a lot more on this, but this is what it says at the end. So it says a person guilty of an offence under this section is liable on summary conviction to a fine not exceeding level 5 on the standard scale. I don't even know what that means. Just Google that as well.
You're still sharing the code of guidance, yeah?
No, yeah, no, I didn't mean to do that this time. Hold on.
That's what you've been sharing, yeah, yeah.
Here we go. Right, hold on. There we go. So that's yeah, that last bit's the bit that's put in, and I'm going to find out what this not exceeding level 5, whatever it is. Oh, says here level 5 is unlimited. No, level 5 is £5,000. Um, so the answer, I mean, essentially, yeah, you have to be upfront with the council. And obviously there are going to be situations where you generally forget some information, but it's kind of that idea of like, where you've knowingly withheld information, which I'm going to guess the questioner of this question probably is knowingly doing it. Shannon?
Yeah, I mean, so just on the UC front, so obviously it's a different sort of department. I've known people to have their like UC claim completely shut and sort of not be allowed to claim UC for years and stuff, depending on what information they're withholding. So I don't know. It's perhaps a bit more serious on the UC front, just because it can have like maybe a longer lasting impact. Um, in terms of you might not be able to open a claim for X amount of years, or you might not have whatever it is. So yeah, just reiterating the advice to let people know change of circumstances when you know them. And like I think also like people are understanding, right? Like if you have just signed a tenancy and you don't tell them till 2 days later because you've been moving, like I've that's never been an issue. Do you know what I mean? Like it's like, oh, by the way, I moved in 2 days ago. That's not like don't stress about it. People aren't going to start finding you and everything else. It's that openness and upfrontness. Like you do need to sort of, it's a collaborative process, isn't it? Like it's a legal process. So yeah,
Yeah, and it's about doing it knowingly and kind of it's where you kind of responsible for it in the sense that you know what you're doing it deliberately in order to make the council house you. I mean, we didn't because I think one of the things you probably got on your side is the fact that it's quite difficult to actually get a conviction. So because we did a FOI because Bedford's kind of they always kind of make out that everyone's trying it on. So we did an FOI to find out how many people they can ever convicted on it, and they said no, no one ever. So it's not as I say. But yeah, I think just the message to be said like what yeah. You just need to be upfront with your council. It's just it's fraud to not do that basically. So we're coming up to the end of the question. So I don't think, I appreciate some of these newer questions won't have seen my message there, but I put a limit a little while back so that we're not going to be here all night. There are a couple more questions. So someone just asked the question here, essentially, um, it's about kind of allowing someone. So the tenant isn't allowed to let an abusive guest in, are they? They could lose their tenancy. They shouldn't let the abusive father in my opinion. So it will depend on, there's kind of different, there's an interesting point here. So there's different levels of evidence for domestic abuse in different areas of law. Part 7, the homeless application process, is the lowest, the easiest threshold to satisfy, where it basically says that the default position should be to believe people who disclose they've been abused. However, in other areas, so let's say, for example, like Part 6, there generally needs to be a letter from a professional of some kind. Often it does actually specify like police or Marek or something like that. So I would say that as a housing association are probably going to use a kind of a framework more like that than rather than the low threshold. So you're going to have cases where there definitely there is genuine domestic abuse happening, but there's not enough evidence to satisfy the landlord, the social landlord to kind of enforce that. But yeah, I think I actually don't know. Like, it would depend on the housing association. It would depend on the actual tenancy itself. But yeah, certainly, um, they don't kind of they don't kind of tolerate perpetrators, and being a perpetrator or being found to be a perpetrator will often bar you to be able from the housing list for quite a long time. Actually, several years. So yeah, but I don't know. In the real world, it kind of gets very difficult to kind of discern what, how that's actually going to work. Do the other family members see it as abuse as well? We don't know, so it's difficult to kind of enforce, I think.
Yeah, sorry. I was just going to get into deep realms of domestic abuse. So if this relates to the other question about the lad with the father, so that father might be on the tenancy, if it's his house. So in terms of sometimes there's issues with they used to call, or in some situations, the council take the view that domestic violence will be antisocial behaviour, so it'll be nuisance and harassment if it gets so loud and they're arguing and it affects their neighbours and things like that. So try and evict them through antisocial behaviour and things like that. But you're putting, I mean, in family situations where their mother and father are trying to live together and the mother is also a subject to domestic abuse and that son is older. So there's like that family dynamic and how you safely, where the most dangerous time for a woman is when they're leaving the relationship and when a person is leaving. So it all comes down to that and domestic abuse, and there are, fundamental flaws in handling domestic abuse situation because there's no one type fits all. So it has to be case by case basis, and there should be more help and resources available to everybody experiencing the domestic abuse. And that is for children as well, especially if they're classed as adult children and the son is over 18. So we get into the realms of when that happens, and if the father and son are arguing, it turns into antisocial behaviour and things just escalate from there rather than coming at it from a practical point of view and intervening earlier, whereas the lad should have had help earlier from like schools, social services and things like that. Just calling it tough love is a bit awful now. So in terms of he should have had help and for the whole family as council tenants, but that's just not happening nowadays. So it's down to him now to try and get housed sensibly, and that's where someone else needs. And the answer of just don't let him in could really escalate the situation, put the mother in real danger. So, but that's a domestic abuse. I think there's another video
Yeah,
for another time.
I think probably in any situation like that, having contacting professionals, having stuff on their records, which then can evidence and kind of, use as a defense later on in terms of, saying, well, actually, this is what was going on and kind of how this is how we kind of dealt with it. This is why we did X, Y, and Z. I think you're just kind of enabling or kind of providing a bit of a safety net should things get worse. Should things involve ASB down the line or something. Should there be accusations of ASB down the line, you can kind of say, well, actually, no, this was abuse, and we kind of let people know at the previous time. So guys, on the live stream, you've missed the deadline to ask questions for tonight. So any further questions, you'll need to roll on to next week. My advice is for you to put it onto a comment on any video on this channel, and I'll get a notification. We're going to finish tonight just by going back over the remaining questions. In fact, I think this is one question. It wasn't anonymized. Yeah, it was just one. Another one involving domestic abuse, I believe. Yeah. So let me just get the right screen up. So question 16. So this person is under section 189B, which is the relief duty, and told to make a housing application, which I'd take to mean like to get onto the housing register. Appreciate like different staff will use different terminology and so on, which was accepted and suspended still due to still being on the joint tenancy with the abusive ex. Will I be intentionally homeless if I give notice to quit on previous tenancy to have housing application made active again before the main duty is confirmed? So this is pretty ridiculous that this situation has kind of come up. So the short answer is no, you won't be intentionally homeless if you're at risk of domestic abuse. But I would say before you kind of do anything with your tenancy, you should, the professionals involved here should really be helping you through this process. They should definitely not be telling you that if you remove your name from the tenancy, you're going to be making yourself intentionally homeless. That's nonsense. But actually ending that tenancy does involve risk. As Karis has kind of indicated, there's kind of research around what increases the risk of domestic use. Well, if you've got to end the tendency of the perpetrator to make that other perpetrator homeless, well, that's obviously going to lead to an increased risk against you. So it needs careful handling, and council workers should not leave you in this kind of like with a lack of information. There should be a lot more support around you at that point to figure out a way to go forward. Now, in one sense, yes, the tenancy does need to end at some point. Although I'd probably argue that technically it doesn't. The fact is that this person's already been found to be homeless because they're owed the relief duty. So you're only given the relief duty if the council is satisfied that you are in fact homeless. And in this case, because there is a tenancy, what the council is effectively admitting is that it's not reasonable to continue to occupy your joint tenancy. Which is code for saying you're homeless. And what that essentially also means is that you cannot be found intentionally homeless from it, because although you had accommodation, it was not reasonable to continue to occupy. So giving it up or leaving it or whatever cannot be seen to be intentional homelessness. So yeah, the short answer is this person would be safe. However, and I don't quite know how you go about this. Really, those professionals involved in that situation should have done a much better job. If you haven't, if someone in this situation hasn't already, they should probably approach a domestic abuse service. There would potentially, I could well imagine really that someone who had been found to be homeless, there's already evidence of domestic abuse here. It's already been accepted. There should have been a dash form done to see if the person could get an IDVA. There's a lot of stuff that should have been done here, and definitely should not have left someone fearing that they'd be found intentionally homeless if they stop the tenancy. So having said all that, potentially what might have happened here is that the housing officer's done a good job, recognised domestic abuse, engaged with the relief duty, got them onto the housing register, and then some absolute jobs worth in the housing register team has said, well, you've got a tenancy, so you can't be, we can't help you, something like that. So it may well be that there's more than one staff member involved here, and I'd probably go back to the more helpful one and say, look, I've just been told I've got to, I'll be intentionally homeless if I give up the tenancy, and just basically get everything in writing, get them to fix it themselves, get the house, get the different staff members to talk to each other and not leave this person in this situation. So yeah, hopefully that answers it. As I say, yeah, so the short answer is no, you're not going to be intentionally homeless. The council's already accepted you are homeless by giving the relief duty. But in terms of ironing out the problem, I'd say if there was an officer which was already being quite helpful and nice, then go to that person and say, this is what's happened, this is what I've been told, and that officer will hopefully go away and sort it out. And this probably is not a bad idea anyway, is to go and pursue more support with domestic abuse anyway. So from an IDVA, there might be specialist service, check out Mankind or Women's Aid. Mankind, do I mean that? Mankind? Mankind? I think Mankind.
Mankind.
Mankind, okay.
Yeah.
Yeah, so just check them out, have a look on their website, see if you've got anything local. There might well be some local domestic abuse services as well. There often are. Often, they can be really, really helpful. So yeah, and hopefully that just, in one sense, they need to give you some decent advice about what to do with that joint tenancy and how to handle it. But that's not on you, that's on them to tell you what to do, or tell you what your options are. Yeah, cool. So that's it for tonight. As I say, guys, if you're still on the live chat asking questions after that cut-off point, I'm trying to work out if there's a better way of doing the cut-off point, as in so you can definitely see it. I'll see if I can. Not sure. Can I shut? I don't know. You are shadowing that. Yeah, but that's it. There's this from this week, guys. So yeah, roll questions over, put them into the comments on the videos, because you'll definitely get them answered. Then that's the only way you'll guarantee to get questions answered, or turn up at 7:30 on the dot and get in there quick. But even then, technically, you're not guaranteeing it. We hope this has been useful, as we always hope it is. Some really difficult situations people are dealing with tonight. It sounds like there's kind of quite a few situations involving people like on the cusp of, or kind of having to evidence that they are owed some sort of duty, which can be the most difficult ones to win. So as always, if you can get a solicitor, if you can get additional help, if you get a professional behind you who's actually knowledgeable and is willing to challenge a council, then yeah, then absolutely pursue that. Because some of these questions, I think that one we talked about earlier with this kind of tough love one here, that's a tough one to win. That's if you're not backed up by some decent professionals, that's going to be hard. That's I don't know how likely it is you're going to win that argument. So but yeah, we'll see you next week, guys. As we'll be on Will's channel on Monday. I will be anyway. I don't know about Shannon and Karis. We get nods. So yeah, all four of us might be there, and I'll be here next week with whoever else turns up. So yeah, in the meantime, keep the questions coming, guys. And thanks for the support in the channel as well. Just that, yeah, just want to say thank you to all the people just kind of inputting. I know there's kind of a lot of comments coming in that aren't questions, that just kind of add to the information and add to the kind of the conversation. So I appreciate that. So yeah, see you next week.